The Law of Property Act 1925 is one of the most important statutes governing land law in England and Wales. It was enacted as part of the 1925 property legislation reforms, whose aim was to simplify, modernize, and rationalize the law relating to land ownership and transactions on land. Before 1925, land law was complex, technical, and uncertain, with many overlapping estates and interests. The LPA 1925 reduced these complexities by limiting legal estates, clarifying legal and equitable interests, and regulating co-ownership, conveyancing, and trust of land. The objectives of the Law of Property Act 1925 are: the main objectives of the Act are simplification of land ownership, reduction of legal estates and interest, facilitation of conveyancing, protection of purchasers, and a clear distinction between legal and equitable interests, as well as the modernization of land law. Legal estate in land, Section 1, subsection 1, the Act restricts legal estate in land in two forms. This fee simple absolute in possession, commonly called freehold, where ownership for an unlimited duration can be inherited. Terms of years absolute, commonly referred to as leasehold, it covers ownership for a fixed or determined period. All other estates must exist in equity only. Section 1, subsection 2 of the Act, legal interest. Only certain interests can exist as legal interests, including easements, profit upon rent, legal mortgages, rent charges, rights of entry. All other interests, in e.g., restrictive covenants, beneficial interest under trust are equitable. Equitable interests, interests not recognized as legal under Section 1 of the Act, operate in equity. For example, beneficial interest under a trust, restrictive covenants, equitable leases, equitable mortgages. Equitable interests are enforceable against everyone except a bona fide purchaser for value without notice unless protected by registration. Trust of land and co-ownership, sections 34 to 36. This covers abolition of legal tenancy in common. The Act abolished legacy tenancy in common. Land held by more than one person must be held on trust. Now, forms of co-ownership. We have joint tenancy, unity of possession, interest, title, and time, right of survivorship, jus accrescendi, tenancy in common, equitable only, distinct shares, no survivorship, shares passed under a will or intestacy. Section 35, subsection 4, maximum number of legal owners. The maximum number of legal owners must be four trustees may hold legal title, beneficiaries hold equitable interest. Section 36, subsection 2, severance. A joint tenancy in equity may be severed by written notice, mutual agreement, and course of dealing. Overreaching. Sections 2 and 27 gives us the meaning of overreaching. Overreaching allows a purchaser to take land free from certain equitable interest, provided that purchase money is paid to at least two trustees. The equitable interest attaches to the purchase money, not the land. This protects purchasers and ensures marketability of land. Effects of overreaching. Beneficiaries lose rights against the land. They gain rights against the proceeds of the land. See the case of City of London Building Society and Flegg, 1988. Conveyancing and formalities, section 52, covers deeds. A conveyance of land must be made by deed, except for short leases of less than or equal to 3 years, resulting on constructive trust, section 53, formalities for equitable interest. Declaration of trust of land must be in writing. Disposition of equitable interest must be in writing and signed. However, constructive and resulting interest are exempt. Mortgages and charges. The Act recognizes legal mortgages created by demise or subdemise. Historically, a charge by deed modern method, mortgages obtain legal protection and powers under the Act, including power of sale, right of possession, and appointment of the receiver. Powers of trustees, section 14 and related provisions. Trustees have powers to sell land, lease land, manage trust property. Courts may intervene where disputes arise, especially regarding sale of family homes, competing interests of beneficiaries, now largely governed by the Trust of Land and Appointment of Trustees Act 1996, but rooted in the LPA 1925. Settled land and rent charges. The Act introduced settled land system, now largely obsolete, regulation of rent charges, powers relating to succession and settlement. Much of this has since been reformed or repealed, but the Act laid the foundation. Relationship with other 1925 legislation. The LPA 1925 operates alongside Land Registration Act 1925/2202, Trustee Act 1925, Settled Land Act 1925. Together they form a coherent reform package. Importance of the LPA 1925. The Act simplified land ownership, it increased certainty, promoted efficient land transaction, formed the backbone of modern English land law. Despite their later reforms, many core principles remain in force. In conclusion, the Law of Property Act 1925 is foundational to English land law as it limits legal estates and interests, distinguishes legal and equitable interests, it regulates co-ownership and trust, protects purchasers through overreaching, provides structure to conveyancing. For undergraduate law students, understanding the Act is essential as it underpins topics such as co-ownership, trust of land, mortgage, conveyancing, and equitable interest. If you find this video useful, please comment and let's share your own experiences in the next. Till we meet again,